Okay, so hello everybody, welcome to the webinar. So the title obviously is Abortion in the UK, Law, Access and Reform, and it is supposed to be an hour long, so if you're on like your lunch break from work or whatever and need to bow out early, but you want like the rest of the slides, I put my email address there just in case you want them. So what we're going to cover is I'm going to give a brief overview. I'm operating on the assumption from the position, the starting point that nobody has like a huge amount of knowledge. So I'm just going to set the scene to begin with. And then I'm going to give the historical context for the current legislation. And then I'm going to outline the current law in Scotland, England and Wales. And then I'm going to do a separate wee section for Northern Ireland. That will just be a short section, but you'll see why when we get there if you don't know already. And then I'm going to give some considerations for whether or not the current law is what it should be, or whether we think there's some areas for improvement. Then I'm going to cover the impact of lockdown, because lockdown has made changes both to the availability of services and the ease of access, and has also caused there to be some quite major changes for the pandemic era. And then I'm going to have a wee bit of looking to the future. How can we take all the preceding considerations, the issues and what's come up during lockdown, and apply that to maybe have a better piece of legislation for the future that's more in keeping with current times. So to begin with, I just thought what we're going to cover is the deliberate termination of a pregnancy, and we're talking about it in a medical sense. So you can two types of medical abortion available, which is medical abortion and surgical abortion, and the main difference is their invasiveness and also what point of gestation it can be done up until. So with medical abortion, it's known as the abortion pill, which is actually two pills. You take one, you go to a clinic and take one, and then 24 or 48 hours later, you up to 10 weeks can take it at home. This has been from 2017 in Scotland, a wee bit later in Wales, and then from 2018 in England, you've been able to take the second up to 10-week pill from home. But for the up to 24 weeks one, you will take it in the clinic, you go home, and then you'll come back 24 or 48 hours later for the second one. And then surgical abortion is obviously slightly more invasive, but it's still considered a minor operation. And the difference between the two procedures isn't relevant, but is a different kind of surgical procedure. And the main difference is what point of gestation it can be done up until. So vacuum aspiration can't really be done after the 14 or 15 week mark. The NHS guidance is that anybody seeking an abortion should be given the option between the medical and surgical. That's policy anyway. I don't know how well that translates into practice. So what is it not? This is what we're not talking about. We're not talking about contraception at all in this webinar. We're not talking about natural uninduced miscarriage or maliciously induced miscarriage. We're also not talking about emergency contraception, i.e. the morning after pill, because while that's often lumped in with abortion in any kind of conversation, it's not an abortion. It works the same as contraception in that it prevents fertilization rather than actually terminating an embryo or a fetus. So why is this an important issue in terms of, because this is the Young Women's Organisation Scotland, I've framed it kind of in a like, why is this important to feminists in general? So all humans, and this is a particularly a feminist issue, is control over your own body and self-determination. Also reproductive autonomy comes under that umbrella. So in kind of the literature, the discourse, reproductive autonomy is now also kind of used to talk about like access to IVF on the NHS, things like that. I've used reproductive autonomy discussion when talking about whether or not we should have cloning available for human reproduction. But you can't really have reproductive autonomy without the fundamental choice of whether or not to be pregnant once you are pregnant. And then again, without that, more broadly, it allows you to exercise control over your life, because if you end up pregnant in a situation you don't want to be, that can potentially set your life on a completely different path. And so women or as people are assigned female at birth, for it to be able to have their complete control over their life, that would not be possible without access to sufficient abortion healthcare. So similar to reproductive autonomy, but like kind of a different branch of the same consideration, is bodily autonomy. So as humans, we all want control over our own body. We don't want anything more invasive than we absolutely have to have, and this is a general principle of medicine. And the way that we practice it now, like you need to consent to medical procedures, and this is also relevant in pregnancy. So in theory, in a pregnancy, if a pregnant person goes to a hospital and they are deemed to need a C-section but they want a natural birth, vaginal birth, they can't be forced into getting a cesarean section unless they're deemed incompetent or to not have medical capacity. There's a whole body of things to read and discussion to be had about whether or not that is actually what happens all the time in practice. It's not. But if we in theory don't have to have a medical procedure to protect the fetus just before it's born, that surely should extend all the way through, and you should be entitled to healthcare to end that pregnancy earlier on. So I keep saying healthcare. Abortion is fundamentally, it is healthcare. It is a medical procedure, and should be regulated as such. It should be treated the same as any kind of other medical procedure that you'd go to the doctor for. And whether that is true in practice in the UK, we will come on to later. So also, the regulation of abortion is important for safety, because whether or not it's legal, whether or not it's accessible, it's still going to happen. So there's a whole history of illegal, or like what is commonly known as back alley abortions. So dodgy pills in the 1930s. They used to put adverts in magazines and newspapers talking like as if they were advertising, I think it was a menstrual decongestant or something like that, but like that was code for abortion pill. And often they'd be like, the very cheapest one would be like laden with lead and would result in like death or blindness of the people that took them. And often you'll see in campaign materials like the symbol of the coat hanger, because that was often thought, or like knitting needles were often like used to give like dodgy procedures. So whether or not it's legal and accessible through proper healthcare, it is going to happen. So that is fundamentally why it's important to have a proper system and to have it be properly and safely accessible. So when we're evaluating the legislation or the policy to do with this kind of thing, it's important to have in your mind whose interests we care about protecting, whose interests we care about furthering, and whether or not these interests are well reflected in the legislation or the policy that we have. So whose interests are relevant? First person obviously is the pregnant person themselves. Their interests are, they want good access to medical procedures. So this can be hampered by abortion not being available on demand or them not having a right to an abortion. It can also be hampered by if there are loads of administrative delays or procedural delays or protesting delays. And this can also be impacted by, like, if there's a postcode lottery, if your access to abortion is dependent on living in an area with good access to abortion. And also we'll come on to vulnerable individuals more later, but the point is that just if you are in a vulnerable group, your access might be slightly less readily available than other people. So when we're considering how to regulate or provide services, we need to consider access for all. Pregnant person also has an interest in their autonomy being respected, and I've put medicalisation as a wee subheading there. Medicalisation could either go in the interest or against the interest of the person. So is it against the interest in that it's all about the doctor's opinion, it's not a right, it's not a choice, it's more about whether or not it's deemed for that person to be good clinical care, or on the other hand, it could be a good thing if it's available readily in the same way as contraception is, for example. And then again, I put respect for women's rights, acknowledging that it's not only women who get pregnant, but in the discourse, it's generally referred to as women. So in the legislation that I'm going to get onto in a minute, it does say women. Just adjust that in your mind to be pregnant person. But also when we're talking about this, it does generally come down to like classic women's rights arguments. So whether or not the law is too paternalistic, too prescriptive, and whether or not it's keeping up with current morality, current concerns, current public opinion. These are all things that would be relevant to the pregnant person's interests. Another group is medical professionals. They have an interest in doing good for patients. So beneficence is a fundamental tenet of medical practice. So doing good, not doing harm. And this argument, depending on the individual medical practitioner, could be we want to do good for the patient and provide the service, or we want to do good for the patient and this doesn't include providing the service that would actually do harm to the patient. Again, medical professionals in the literature raised quite a lot the issue of medical discretion, that they want to be able to have it not, they want to be able to use their own medical discretion and expertise and decide whether or not this is, in this individual case, a procedure that would be beneficial to the patient. And they say that if we allow it indiscriminately, doctors become no more than lab technicians. This interest in particular, I mean, you can decide for yourself which interests you think are relevant in your mind to your evaluation of the law or whatever, but to me this one's a wee bit suspect. So medical professionals, some of them also want the right to conscientiously object. We'll come on to the provisions for that later, but if they have their beliefs that they don't want to provide abortion, they want the option to be able to bow out of that particular procedure while still being able to be a healthcare professional. The fetus's interests, again, you can decide whether or not for yourself you want to consider the fetus's interests. Do we think that's relevant, or it should only be considered in the pregnant person? Proportional moral status essentially means we as a society generally think of a fetus right before birth as being vastly different to a fetus the day after conception, and this is reflected all over the place with like time limits put in place for different procedures. Do we feel more funny about it just before birth? I don't know, that's up to you. And the fetus, we're going to get on to the discrimination and like aborting a fetus with like a abnormality or a disability, but that's the kind of things we're putting in fetus's interests. Again, entirely up to you if you want to consider them or not. And the fourth person or group with an interest is society at large. So we want all our laws, everything to correspond with the current attitudes and the morals of the day. So in a society where there's 99% support for abortion, but it's completely outlawed, that doesn't line up and that doesn't make sense. Nor does having it fully available in a society where everybody thinks it is completely morally wrong. I've put this quote here, and it's talking about, this is Emily Jackson. She does a lot about reproductive and medical law, but there's an assumption that a woman's reasons for wanting to terminate pregnancy are a matter of legitimate public interest. So this is not only should abortion be allowed or not allowed, maybe it's the reasons, the justifications that are given are what we should be legislating on. So those are the interests to kind of bear in mind when we evaluate whether or not the law is appropriate and good. So the law in Scotland, England and Wales. I've called this historical context because we're taking you back to 1861, but this law is still in force. This is still this is fully legally standing. This is still relevant. So, Offences Against the Person Act 1861, it's a Victorian statute. Section 58 says that a woman with the intent to procure her own miscarriage, i.e. get an abortion by means of a poison or other noxious thing, or using an instrument, etc., shall be guilty of a felony and be liable to be kept in penal servitude for life. That's quite harsh. Moving on to section 59, this is procuring drugs, etc. to cause abortion. This is about giving the drugs, giving the instrument to the person. So this covers like the doctor or a friend or anybody who helps procure the miscarriage. Moving on to Infant Life Preservation Act 1929. This is the punishment for child destruction. This one is relevant for two reasons. So, one, it covers the situation where, trying to word this delicately, covers the situation where in between abortion and child murder, where it's still essentially being born, it covers that bit that was previously missing between murder and abortion in the previous act that outlaws this, but it also brings in an exception that if it's 28 weeks or more, it will be permitted if it's to preserve the life of the mother only. And this case down here, R against Bourne, this was a doctor whose patient was 14 years old and has become pregnant in very, very tragic circumstances. And the doctor, and it was before 28-week mark, so the doctor admitted in court that he had helped procure the abortion, which was quite a radical thing to do, as in to admit that openly in court, because it didn't fall under this 28-week exception. But what he said was, because the court was saying it doesn't actually, as in it didn't fall within 28-week exception because it happened before the 28 weeks, but this statute doesn't actually legislate for that. He said that this girl, the 14-year-old, was going to commit suicide if she was going to take her own life if she had to go through with the pregnancy. So this wasn't actually a physical condition that was going to end her life, but the court was on his side and acquitted him of it because he said so convincingly that like the mental health was something that was also to be taken into consideration. So this 1929 Act is basically the last piece of legislation there was right up until 1967. But that doesn't mean that the campaigning and the concerns stopped in between that time. There was actually a group set up to try and get clarity on the law and try and get like basically it was a pro-abortion concern at the time. There had always been campaigns, but in 1939 it was going through Parliament, it was being discussed, but then it was shut down because of the Second World War. And again, campaigns kind of throughout, but really things started changing in the 60s with like availability of the contraceptive pill and just general attitudes to sex changing. And then the Abortion Act 1967 was introduced, came into force in 1968. This is the one that we're operating with mostly now. So this is essentially the basis of the current law. So what we have is, if you follow, I've made it rainbow to try and make it easier to read because I appreciate it's a lot of text on one slide. So if you just follow my mouse if you can. So this is, to be clear, an exception to the law. It's not decriminalising abortion, it is an exception to the previous laws, notably the 1861 Act. It requires the procedure to be carried out by a registered medical practitioner after 2 registered medical practitioners have signed off on it. And they have to sign off based on, based on one of the following conditions. So the one in red, A, that is that the pregnancy has not exceeded its 24 weeks, so that's up to a 24-week limit, and that the continuance of the pregnancy would involve risk greater than if the pregnancy were terminated of injury to the physical or mental health of the pregnant person or any existing children of the family. This is actually very wide-ranging. This is a very liberal condition. It's up to 24 weeks. Medically, any continuance of a pregnancy would generally involve a risk greater than if the pregnancy were terminated. So as long as that can be shown, which it very easily can, abortion is available up to 24 weeks, provided it's been signed off by 2 registered medical practitioners. The vast majority of abortions in the UK come under this red condition. Why do I keep doing that? So it's figures are variable slightly year to year, but it's roughly 98% of abortions come under A, and about 9 in 10 are actually done before the 12-week mark. So when we think about late-term abortions, that is a very, very, very small minority of the actual cases. But beyond the 24 weeks, there can be, if it's necessary to prevent grave permanent injury, physical or mental health of the pregnant woman, or to prevent risk of life to the pregnant person. Very few cases come under those ones, but is done when necessary. And then D, that there's a substantial risk that if the child were born, it would suffer from such physical or mental abnormalities as to be seriously handicapped. We're going to focus in on D for a minute. So there's a couple of, maybe issues that can be flagged up with Section D, and that is, number 1, the meaning of the terms. What is a substantial risk? What is an abnormality? What is seriously handicapped? Words like substantial and seriously aren't specifically definable. The Royal College of Obstetricians and Gynecologists have issued guidance on what both of those means. So I've got it written down here. The substantial risk is informed with no personal involvement in in pregnancy and outcome. So basically it means it's not the woman's or the pregnant person's idea of whether or not the risk is substantial. And serious handicap is defined as a person is seriously handicapped if need for a human hand dependent performance most of the time. So this is like I don't know, it's taking a position on a disability or abnormality, but what it's not doing is giving a definitive list of these abnormalities. This is different to like other kinds of reproductive policy. So with pre-implantation genetic diagnosis, when you're testing an embryo for an abnormality to see whether or not to implant it, there's a set list of, I think, 400 conditions that can be tested for. That doesn't apply to abortion, so that is slightly more discretion, again more vague. There's nothing in the actual legislation to say anything prescriptive. There's concern, again in the literature and the criticism, that essentially not allowing people to be born with some conditions will contribute to stigma for people already living with conditions and people that do in the future become born with these conditions. There's also a concern that it's discrimination against certain fetuses but not others, and we don't allow abortion based on you want one gender or sex of a child and not the other, but we do allow it in this case, which then begs the question, whose interest again is this in? So is it in the interests of the fetus who's not going to be born or would be born but be seriously handicapped? Or is it in the interests of the pregnant person to not have to raise a child with abnormalities or who is handicapped? Don't know, that's up to you to decide. Or is it in the interest of society to not, again, back to the stigma and discrimination, to limit the number of people being born with serious handicaps or abnormalities? I'm going to take you now to section 4 of the Abortion Act. Conscientious objection, I touched on that very briefly earlier. So that is if a medical practitioner doesn't want to participate in the treatment, they can conscientiously object, and that means they don't have to. It says in the legislation that they will not be under any duty to participate unless it is necessary to save the life or to prevent grave permanent injury. So you're not allowed to conscientiously object if it is a necessary procedure at the time. The 2-doctor requirement is the same for that as well. It doesn't need to be 2 doctors in the cases of an immediate emergency. And in any proceedings for a court in Scotland, a statement by a person to the effect that is a conscientious objection is sufficient. You just need to say you conscientiously object, and that's it. There was a case that went to the Supreme Court of the UK in 2014. It was the Dugan case, it's called, Greater Glasgow Health Board. 2 women, 2 midwives, I think. Yep, 2 midwives were involved in the this part of the kind of labour and abortion kind of genre of medicine, but they weren't involved in the actual giving of the treatment at all. But what they said was that they objected anyway and they wanted absolutely no part to do with it. So then in the case, the court put a limit on what can be considered involvement. It was Lady Hale, if you remember her. Any lawyers in the audience will definitely know her. You might remember her from the spider brooch if you are not a lawyer. She's been on the news recently, last year. She is great in general, but she said we need to interpret this provision very strictly. If it is not a treatment specific to the wording of the legislation, i.e. if it isn't if you're involved in like the management, you're involved in aftercare, anything like that, you are not allowed to conscientiously object, because these things weren't actually affected by the Abortion Act itself coming into play. So if it wasn't illegal or unlawful before this act, it's not something that you can conscientiously object to, i.e. running the admin of the clinic, i.e. Providing nursing care afterwards, because you could provide nursing care to an abortion before it was legal. Before we get on to Northern Ireland, I'm just going to touch briefly on the differences between Scotland, England and Wales. So Scotland, England and Wales. The two old acts, the one from the 1920s and the one from the 1860s, actually only applied to England and Wales. There were related common law offences in Scotland, which means that essentially, well, depending on how you interpret it, actually this Abortion Act 1967 might have actually made it a wee bit stricter, because prior to that, under Scottish common law, you could actually get an abortion, or a medical practitioner could deliver one if it was done in good faith, which basically means for the benefit of the woman, to save her life, etc. So this two-doctor requirement actually maybe made it more strict, but the law was not legislation, so it wasn't clear. We now have it clarified. We know where we stand now with the 1967 legislation. So Northern Ireland, the 1967 legislation never applied. They were still operating purely under the Victorian legislation. But again, as I touched on earlier, that does not mean that abortions weren't happening. People from Northern Ireland were travelling to England, travelling to Scotland to get access to the services over here, which obviously came at great cost, was probably quite difficult to do discreetly, and also took up a lot of time, have to take time off work, potentially, depending on when you can get time to actually travel, might have pushed back the point of gestation at which the actual abortion would take place. Or if they weren't travelling, what they would do is buy pills on the internet. Again, pills, whether or not they're safe, if they're not regulated, how do we know how safe and effective they actually are? But even at that, it's illegal. Again, remember, if to procure your own abortion or for somebody else, that is illegal under the 1861 Act. So buying pills online was still a criminal offence, and they'd be stopped from coming into the country quite a lot. And actually, some people were even still prosecuted for it. I think it was 2016. There was a woman given a prison sentence for buying abortion pills online. So nothing between 1800s, early 1900s, right up to July 2019, when the Westminster government voted that abortion in Northern Ireland had to be decriminalised if the devolved Parliament didn't reconvene by October 2019. That didn't happen. So again, things were set in motion to actually decriminalise abortion, which was very controversial. The Stormont people have had quite a lot of things to say about that. If you don't know anything about the situation in Northern Ireland, it's resolved now, but the Parliament, the situation with the sitting of the Parliament, it's quite a wild ride if you read into it. That also, in the same way that they did this for abortion law, they also did it for same-sex marriage. You probably saw a lot about that in the news as well, but that was finally legalised in 2019 as well. 2019. So after that was put in place, that we have to decriminalise abortion in Northern Ireland, the Northern Ireland office then had to come up with a framework. How is this going to work? You can't just take the law away and have it be completely unregulated. That's not what we want. What we're going to do, we have to set and come up with a framework for regulation, put the rules in place. It's going to be decriminalised, but what is the framework going to be? The regulations were made public in March of this year, and they're fairly straightforward. So it is legal up to 12 weeks without conditions. So where ours is still an exception to the original crime, it is legal in Northern Ireland up to 12 weeks. You don't need to fulfil any of the ABCD criteria. Further 24-week limit is similar to the one we have in section A, where it's the risk to physical and mental health. And then again, beyond the 24 weeks, there's further conditions without time limits similar to what we have over here. It has to be carried out by a doctor, a registered nurse, or a registered midwife, and there is provision for conscientious objection. I imagine if there hadn't been, there would have been potentially an uproar. So where do we stand now? Northern Ireland, newly decriminalised, very newly decriminalised, not a great deal else to say about that right now. The rest of the UK is still a legal exception to a criminal offence. 2 medical practitioners must sign off. It must come under one of the given 4 grounds. The first one being the vast majority, and there is a possibility for conscientious objection if you fulfil the conditions of the Act, and also backed up by the court. So is the current law fit for purpose? It is relatively permissive. When this was brought in 1967, that was quite good going. Like, it was quite liberal, and it is like fairly accessible up to 24-week mark still. But in the way it's framed, is it reflective of reproductive autonomy? You can't make your own decision about it. Still needs to be signed off by 2 doctors. Again, it is still technically a crime. Now, compared to 1967 when it was introduced, the procedure itself is far less risky. So is there any need for having such strict 2-doctor requirement, such strict laws for the basis of protection of the pregnant person's health? Arguably not. This 2-doctor requirement is outdated paternalism. We've shifted from paternalism, where the medical profession tells you this is what's wrong with you, this is what we're going to do, to more patient-focused care, where consent is a big thing, joint decision-making is a big thing. This does not fit with that model of healthcare at all. It's also out of step with current attitudes. Majority of people now, way more than in 1967 when it came in, are in favour of reproductive rights, abortion rights, and decriminalisation. This includes the general public, this includes legislators, and this includes the medical profession as well. So those ones in green there are kind of like theoretical issues with the law. These ones in purple are like real practical, here's actually tangibly some things that are wrong. So access. Some of the provisions, some of the conditions that have to be fulfilled are kind of a barrier to access for some people, e.g. vulnerable people. So this is people in a coercive or abusive family environment or domestic partner environment, where maybe control of contraception isn't in your hands, control of where you go out the house isn't up to you. So having to go to a clinic once or twice or 3 times with like consultation, actually getting the procedure, and then if it's after 12 weeks going back for another pill, that's a lot of barriers to access for people who don't have a great deal of access outside their house. Similarly, in rural areas, if there's a big backlog and a delay, or not enough non-objecting doctors in your area to sign off, there might be issues with access and you might need to travel to somewhere else. The delay, go back to the delay, Again, NHS policy, it's supposed to be no more than 3 weeks between initial consultation and actually getting the procedure. Does that happen all the time? Absolutely not. Illegal pills, again, buying illegal pills online if you're in one of these vulnerable groups who can't access it readily, and then that again is putting yourself at legal risk. Why? No need these days. So the pandemic has exacerbated the existing issues of the previous slide. If you're in your coercive domestic environment all the time and there's a lockdown, how likely is it that you can leave to go to a clinic once, twice, 3 times? Self-isolation, so people who were normally able to go out and about freely and uncoerced, some of them were self-isolating because they potentially had coronavirus, or they were self-isolating because they were shielding. They can't go out, that putting themselves and others at great risk by going out to a clinic. Unnecessary use of public transport. We were told, particularly at the start of the pandemic, don't use public transport unless you absolutely have to. Similarly, unnecessary trips back in March when you could go out if you were a key worker, going to the shop or going out for daily outdoor exercise. If it wasn't, and obviously for like necessary healthcare, but if there is no need to go to the clinic for a consultation for the pills, because the thing was that we could do it remotely. We could have a remote consultation and then they would post the pills to you and you do the whole thing in the house without making these unnecessary trips. Healthcare professionals were also required elsewhere. Obviously, 2 doctors to sign off on every single abortion consultation. They've got other priorities right now. I think we've all heard about the triage situation. And also loads of clinics had to close due to staff illness and self-isolation. There just wasn't enough staff to open all the clinics. This was British Pregnancy Advisory Service clinics. This was NHS clinics. There just wasn't a lot. There just wasn't sufficient availability, coupled with the whole unnecessary going out of the house and putting yourself and others at risk. So to combat that, what did they do? 23rd of March 2020, UK Government Department of Health issued guidelines for at-home abortions for pregnancies up to 10 weeks. Brilliant, very welcome change. This would mean it would all happen at home, no unnecessary trips to clinics at all. Within, I think, even a couple of hours, the absolute maximum 24 hours. Oops, backtracked on that. We didn't mean to publish those guidance. We're taking that out of the pandemic legislation. Scrap it. So this meant it was reverting back to normal time abortion law, as in clinic, 2 doctors, clinic, potentially clinic for a 3rd time. Much backlash, as you can imagine. Campaign groups, emails to MPs, social media, campaigning for bring back this legislation that you kind of promised and then kind of tried to sneakily take away. So then they backtracked on the backtrack, welcomely. And now the situation is telemedical abortion services are available up to 10 weeks in England and Wales, which this here is exactly the same as this here, with these 2 unnecessary elements of chaos in the middle. And then Scotland soon after introduced similar, but for up to 12 weeks of pregnancy. So telemedical services means it's remote. You have the consultation over the phone or over a video call, and then they post the pills to you. But in saying that, it's still the same criteria apply. So we're not compromising on safety or even the guidance, the ABCD criteria, they still apply. So, which really just shows this can be done and that there's actually not really a need to go to the clinics potentially ever, unless maybe you're in some kind of particular situation, but maybe it shouldn't be policy that everybody goes. Maybe you go if you have a particular need to go to the clinic. Just a thought. But this is currently a temporary policy and will expire at the latest 2 years from now. And by now, I mean March. So how could this inform future change? Some people, I say some people, I mean me, have been banging on about how we need to change abortion law for years. And I mean, many people long before me. But I think this has really highlighted the issues with the current law and shown to the wider public that actually things aren't necessarily as great and as liberal as we thought it was in the UK, and as easily accessible. And it's shown that it can be done differently, with what I was saying with like telemedical abortion services. Why can't that be continued after the end of the 2-year period? There's clearly no clinical need, no absolute necessity, there's no real benefit necessarily to requiring people to go to a clinic several times. So why don't we maybe consider continuing that indefinitely, just making that general policy? It's actually been shown by people or groups, companies that import pills to the UK illegally, that people have stopped sourcing pills online now that they're available readily within your own home, which is obviously only a good thing. Again, yeah, why can't it continue beyond 2-year time limit, or can it? Again, as I said earlier, there is widespread support for decriminalisation. I think up till now it's not necessarily been a legislative priority, but now that these issues have been highlighted, I think there is a very good cause to be made, or a very good case to be made, for actually changing the law and decriminalising abortion completely within the next couple of years, like as soon as there's time legislatively. On Monday this week, if you've seen anything about the domestic abuse bill in news or on social media, there's been quite a lot of chat about that. But there was a lot of campaigns right up to very recently talking about get the government to allow remote services to continue for people experiencing domestic abuse. But what the government has actually done is they said they're going to consult on allowing remote service to continue for all people who want to access the services, which, if that passes, is a change I would welcome massively. So what could legislation possibly look like in the future? Ultimate priority, I think, just decriminalise it. It's been done in Northern Ireland, it's been done in various places. It's completely a feasible thing to do, and it doesn't mean that it won't be regulated. What like doctors groups have said, or groups representing doctors have said, is that we should have professional rather than criminal sanctions, and this would mean the people seeking an abortion wouldn't be criminalised for doing so. But if the doctors were to administer one in a way that wasn't correct, was a bit dodgy, or wasn't fulfilling whatever conditions we put in place in the new legislation, then they'd face professional sanctions in the same way as they would for mistreating any other patient. And this isn't to say that there can't be any criminal sanctions, because criminal proceedings can be brought against doctors if they do something criminal. It also doesn't mean that there won't be a time limit. So we could put a time limit on it, but would we want to do that? I don't know. Either way, it's not for me to say, but just something to think about. It's completely legal in Australia, Canada, no time limit, or no legal time limit, and yet still the absolute vast majority of procedures take place within the first 12 weeks and then like the rest of the majority, up to that 98% kind of number, takes place up to 24 weeks. You see people trying to engage in arguments about decriminalisation and time limits, and they say, well, do you think we should just allow abortions right up to the day before a baby's about to be born? But that's not realistic. Nobody aspires to a pregnancy, letting it run its course and then ending it at the 11th hour. That's just not something that is realistic as a concern that it will be widespread practice. And if it is something that has caused something to happen at the 11th hour, if it's in terms of safety, we already have provisions for that, we can put them in. But at the same time, surely there must be something else going on if somebody suddenly changes their mind a week before their baby's about to be born. And maybe that's something that we should have, like a counselling or some other kind of provision encompassed in the legislation, just to make sure people are getting the best care possible for them at the time of procedure. We could also allow conscientious objection in the legislation. There is a whole wealth of articles about conscientious objection and whether or not it should be allowed. As it currently stands, it is allowed, and personally I've got no objection to the objection if it's not impacting the actual care that is able to be provided. So as long as people are still able to access services, I'm totally fine with a conscientious objection clause going in the new legislation. So, to sum up, in my opinion, current law for Scotland, England and Wales is not fit for purpose. It's not in line with current morals, it's not in line with current attitudes, and it is unnecessarily restrictive and actually prevents some people accessing services. Not fit for purpose, in my opinion. But we have seen some welcome changes brought in to deal with the coronavirus crisis, and there is, as we've seen from just this week, hope for continuation going forward. And I'm hoping this will have some momentum for like continual change. And if we do continue this, the coronavirus changes, maybe that will be a step in the right direction for considering further change in Parliament. And in my opinion, new legislation is completely feasible and reasonable, and the need for new legislation shouldn't be a reason not to consider decriminalising it. And also just a wee nod to Northern Ireland, who went very, very quickly from having like one of the most restrictive abortion laws in Europe to now having one of the most permissible laws in Europe, one of the least restrictive, one of the most liberal. So honestly, good for them. And that's it. That's all I have at the moment. If you want any more resources or anything, email me. I will point you in the direction of any kind of articles, all kinds of writers, and all kinds of current campaigns, as well as I can send you these slides if you want them. So thank you very much for listening.